The defendant stood at the front of the courtroom with an odd, almost relaxed posture for someone who'd been ordered to appear over a serious financial delinquency. The air in the room carried that familiar weight of consequentials, paperwork stacked, dates logged, numbers calculated, and a sense that this wasn't a misunderstanding but a long-running problem. The judge looked down at the case file, then up at the defendant, already aware that this hearing wasn't about a single missed payment. It was about a pattern, a growing balance, and a court that had heard every excuse imaginable. The judge began by summarizing the record in a steady voice, one fact at a time, the way courts do when they want the record to be airtight. The amount wasn't small, and it wasn't theoretical. It represented months and years of unpaid obligations, either back child support that had accumulated into a crisis or unpaid taxes that had followed the defendant like a shadow. The judge emphasized that the court had issued notices, deadlines, and opportunities to comply. This was not the first time the system had asked the defendant to do the right thing. Then the judge said the number out loud, deliberately and clearly, so there would be no pretending later. "You owe $50,000, the judge stated, and the courtroom seemed to tighten around the words. The defendant didn't react the way most people do when they hear a debt that size in open court. There was no panic, no apology, no visible fear, just a faint smile that looked like confidence rather than concern, as if he believed the number didn't matter because he'd brought something that would erase it. The judge leaned forward slightly, voice firm but measured. "The court needs to know how you intend to pay," the judge said, and the question landed with the force of a deadline. There are plenty of people who come into court with payment plans, documentation, proof of employment, or at least an honest explanation of hardship. The judge's question left room for reality, responsibility, and solutions, but it also made clear that the time for vague promises had passed. The defendant's smile widened, and that shift alone made the courtroom uneasy. It wasn't the expression of someone relieved to finally fix the problem. It was the expression of someone who thought he'd discovered a loophole. He reached for a folder like he was about to present a winning hand, sliding it open with careful, almost theatrical slowness. He didn't look ashamed. He looked excited, like the judge had just asked him to perform something he'd been rehearsing for weeks. Without hesitation, the defendant pulled out a single sheet of paper and held it out to the bailiff with a confident nod. He didn't ask permission. He didn't explain first. He simply acted as though this paper carried the power of a certified payment instrument. The bailiff took it because that's what bailiffs do and court receive items for the judge, but his caution was obvious. The way you might handle something that feels wrong before you even know why. The defendant spoke with a polished rhythm, like he was reciting something memorized from a video or a forum post. "I have accepted this obligation for value," he declared, loud enough to be heard clearly. Then, with a smug certainty, he added, "I am discharging this debt using my unlimited exemption." He said it like a magic phrase. Like the moment he spoke those words, the courtroom would be forced to acknowledge them as legally binding. The bailiff carried the paper to the bench and handed it to the judge. The judge looked down at it, and the first expression wasn't anger, it was confusion. The kind that comes when the mind tries to categorize what it's seeing and can't find the right file drawer. The document didn't resemble anything official. It didn't carry the marks of a bank, a government office, or a recognized financial process. It looked homemade, and the confidence behind it only made it stranger. As the judge examined it, the details became impossible to ignore. It was printed on ordinary computer paper, the kind you buy in bulk, and it had been written on in red ink with dramatic strokes, oversized words, underlines, and flourishes meant to look authoritative. Near a signature line sat a smeared red thumbprint, pressed down like an old-fashioned seal, and the amount, bold and absurd, was written as $10 million, as if exaggeration could substitute for legitimacy. The defendant watched the judge's face with the satisfaction of someone expecting victory. He seemed to believe the size of the number guaranteed success, that if the debt was $50,000, then a $10 million instrument would do more than cover it, would overwhelm the system into compliance. He stood there like he'd just solved the case in one move, waiting for the judge to announce that the debt was discharged, the hearing was over, and he could walk out validated. The judge read the paper once, then again, slower, the second time. The silence stretched, and the room began to understand that this wasn't a routine misunderstanding. It was something else, something the defendant had committed too deeply. The judge's eyebrows tightened, and the look on the bench shifted from confusion to irritation. Not because the document was persuasive, but because it was so obviously not real that presenting it to the court felt like an insult to basic logic. Finally, the judge looked up and spoke in a sharp, controlled tone. "Sir," the judge said, holding the paper lightly between two fingers, "this is a piece of printer paper with a red thumbprint. This is not legal tender. You cannot pay child support with imaginary money." The statement wasn't just for the defendant. It was for the record, and for anyone who might later claim the court refused a legitimate payment. The court was making it clear this wasn't legitimate. The defendant didn't back down. In fact, he seemed prepared for resistance, like he expected the judge to object so he could deliver his next lines. "It is backed by the full faith and credit of the United States," he insisted, voice rising with certainty. "My strawman account has unlimited funds. You are required by the UCC to accept this instrument." He spoke as though saying the right acronyms in the right order would corner the court into submission. The judge stared at him for a long moment, the kind of stare that communicates, without words, that the bench has heard this nonsense before. The judge's voice grew colder. "Sir, you are not teaching a seminar here," the judge said. "You are in court because you have unpaid obligations. Nothing you have presented changes that fact." The defendant tried to jump in, but the judge continued, making it clear that confidence and volume do not convert fantasy into money. The defendant launched into the myth behind his payment, explaining it with the confidence of someone who truly believed he'd uncovered a secret system. He claimed that $10 million came from a hidden Treasury direct account created the moment his birth certificate was issued, as if his existence automatically generated a government fund. He talked about trusts and bonds, about how the government supposedly trades people's names as financial instruments, and about a strawman version of himself that held unlimited credit. He framed it like a revelation, not realizing that to the court it sounded like an attempt to dodge responsibility. The judge's expression hardened further, moving from irritation into something more serious, concern and anger at the implications. "Let me be clear," the judge said, enunciating carefully. "There is no secret account tied to your birth certificate. There is no hidden fund that you can access with homemade documents, and there is no unlimited exemption that erases court-ordered obligations." The judge wasn't debating the defendant's worldview for fun. The judge was shutting down a dangerous misconception that often leads people into legal trouble. The defendant insisted again that the Uniform Commercial Code required acceptance of his paper, as if the court were a cashier at a register and he'd found the right coupon. The judge cut him off. "The UCC does not compel a court to accept fraudulent instruments," the judge said, "and it does not override court orders or substitute for payment in lawful currency." The defendant's confidence began to wobble at the edges, but he tried to mask it by repeating the same phrases: acceptance for value, discharge, full faith and creditly repetition could turn them into truth. At this point, the judge lifted the paper slightly, as if to emphasize how absurd it was that the defendant expected it to function as money. "This is not a check," the judge said. "This is not a money order. This is not a cashier's check. This is not a valid instrument from any recognized institution." The judge paused, then added the sentence that landed like a gavel strike. "This is something you made." The defendant shifted his weight, realizing the performance wasn't working. The judge's tone became blunt and severe, the kind used when a court needs to protect the process from being manipulated. "Trying to pass this fake instrument to a court is fraud," the judge said, "and if you attempt to use it elsewhere, you could face additional consequences beyond this case." The defendant opened his mouth to argue again, but the judge raised a hand, signaling that the court was not interested in more slogans. The issue was simple: pay with real money or face enforcement. Then the judge asked a final, practical question, giving the defendant one last chance to step back from the cliff. "Do you have any legitimate payment today?" the judge asked. "Cash, a verified cashier's check, proof of funds, documentation of a payment plan you've already started." It was the kind of question that offers an exit ramp one final chance to return to reality. The courtroom waited, because the answer would determine what happened next. The defendant didn't take the exit ramp. He refused to engage with the question on its terms. He said he didn't consent. He said he'd already discharged the debt. He said the court was obligated to recognize his paperwork. He kept trying to push the hearing into his own framework, where words were currency and conviction was proof. But the law doesn't operate on belief. The judge's patience had reached its limit, and the defendant's refusal to comply made the outcome inevitable. The judge's voice became purely procedural, stripped of emotion, the tone of consequences. Since you refused to pay with actual US currency or any legitimate method of payment, the judge said, and since you are attempting to satisfy a lawful obligation with a fabricated instrument, I am finding you in contempt. The words in contempt hit differently than an argument. They weren't a rebuttal. They were a ruling, and rulings come with immediate effects. The defendant's posture changed for the first time. A subtle tightening around the shoulders, a flicker of uncertainty in the eyes. The judge looked toward the bailiff and delivered the instruction that ends debates instantly. "Bailiff," the judge said, "take him into custody until he can come up with $5,000 in real cash." The judge emphasized real cash, like a correction to the defendant's entire worldview. The courtroom shifted again, because now this wasn't about a theory, it was about arrest. As the bailiff approached, the defendant's confident expression collapsed into protest. He tried to speak, tried to assert rights, tried to keep the script going, but the script wasn't a shield. The bailiff didn't argue with him. The bailiff simply did the job. The defendant looked around the room as if someone would intervene, as if the sheer audacity of his belief would force reality to bend. But no one moved, because everyone understood something the defendant refused to accept. Consequences don't negotiate. The judge delivered the final clarification, not as a dramatic flourish, but as a necessary statement for the record and for the defendant's benefit. "There is no pot of gold at the end of your birth certificate," the judge said. "There is no secret account, and trying to pass this fake instrument to a court is fraud." The sentence carried the weight of finality and ending not just to the stunt, but to the idea that clever wording could erase responsibility. The defendant had walked into court believing he'd found a loophole. He was leaving in custody, facing the reality he tried to deny. When the courtroom returned to its routine, the lesson lingered like a warning sign. The defendant's problem wasn't just the debt, it was the decision to gamble everything on a fantasy that promised freedom from obligation. The court had offered paths that exist in the real world: payment plans, verified funds, compliance, accountability, but the defendant chose a homemade document and a conspiracy myth instead. And the result was painfully clear. Courts don't accept imaginary money, and they don't reward performances dressed up as legal strategy. They enforce orders, and when someone refuses to comply, the system responds in the simplest language: it has contempt, custody, and the price of coming back to reality.